Hello and welcome to Verdictum. I'm Sheetal June and you're watching today's legal news where we update you with the latest legal developments across the country and world. Starting with the headlines. Candidate placed in selection list gets no indefeasible right to be appointed even if vacancies are available, Supreme Court. Decide amendments to MMDR Act in 2 months, Supreme Court to center. Supreme Court dismisses PIL seeking CBI probe into Tirupati Laddus row. 2018 Amendment to Specific Relief Act retrospective in nature, Supreme Court allows review. Now the news in detail. The Supreme Court has reiterated that a candidate placed in the selection list gets no indefeasible right to be appointed even if vacancies are available. The Constitution Bench considered whether the recruitment rules could be altered after the recruitment process had begun. This issue arose in relation to the Rajasthan High Court's recruitment for translator post where a cut-off of 75% marks was introduced after the examination had already been taken place. This led to a challenge by the candidates who argued that the cut-off change violated the principle against altering the rules of the game once the recruitment process is underway. The bench comprising CJI D.Y. Chandrachud, Justice Harishikesh Roy, Justice P.S. Narasimha, Justice Pankaj Mithal and Justice Manoj Mishra held placement in the select list gives no indefeasible right to the appointment. The state or its instrumentality for bona fide reasons may choose not to fill up the vacancies. However, if vacancies exist, the state or its instrumentality cannot arbitrarily deny appointment to a person within the zone of consideration in the select list. The Supreme Court has said that the government's discretion over policy domain does not allow it to keep decisions in limbo, as it directed the centre to take a final call in 2 months on the proposed amendment to the Mines and Minerals Development and Regulation Act 1957 for calculating royalty on extracted minerals. A bench headed by CJI D.Y. Chandrachud was considering a petition filed by Kirloskar Ferrous Industries challenging an anomaly in the MMDR Act and the accompanying rules which permits a higher rate of royalty for extraction of iron ore and other minerals and a lesser royalty for coal. The bench, also comprising Justice J.B. Pardewala, Justice Manoj Mishra, refused to hold the law to be wrong, respecting the government's discretion to take economic policy decisions. The Supreme Court today dismissed a PIL seeking a CBI probe into the alleged use of animal fat in making Tirupati Laddus under the previous Y.S. Jagan Mohan Reddy-led regime. A bench comprising Justice B.R. Gavai and Justice K.V. Vishwanathan was deciding on a petition filed by one social activist and president organization, Global Peace Initiative. In this petition, Paul had sought seeking a comprehensive investigation by the Central Bureau of Investigation into the allegations of corruption and mismanagement surrounding the procurement and preparation of the Laddu Prasadam. The Apex Court on October 4th had set up a 5-member independent SIT to probe the allegations of animal fat used in preparing Tirupati Laddus to assuage the feelings of crores of people while making clear that the court cannot be used as a political battleground. It had directed the independent SIT will comprise 2 officers each from the CBI and the Andhra Pradesh Police besides a senior official of the Food Safety and Standard Authority of India. Allowing the review of 2022 judgment in Saddam Sethi Infra Projects Limited versus Katta Sujata Reddy and others, the Supreme Court has held that the 2018 amendments to the Specific Relief Act are retrospective in its application and not prospective. A 3-judge bench headed by CJI D.Y. Chandrachud and comprising Justice J.B. Pardewala and Justice Manoj Mishra allowed the review petitions against the August 2022 decision, observing that it is marred with errors and clarifying that the doctrine of lis pendens would apply in this case. It was held in the ruling that the 2018 amendment created new rights and obligations that had not existed earlier. This now means that the parties could benefit from the amendments even if the contract was executed prior to its enactment. The 2018 amendment addresses the issue of delays in contract enforceability and provides additional remedies to affected parties. It eliminates the inadequacy tests and enshrines a specific relief as a regular statutory remedy, impacting civil remedies in cases of breach of contract, recovery of property, possession, specific performance, and injunctions. That was all on today's legal news. Thank you and keep watching Verdictum. Subscribe to our channel and download the Verdictum app on iOS and Android devices for the latest legal updates.